Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law. Attorney Dylan Greenwood is the founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level, personalized representation and hands-on approach to every case. I'm Lisa Mosby, your host, and today we're talking about what actually happens during a DWI stop in North Carolina and why those first few minutes matter far more than most people realize. Welcome to the podcast, Dylan.
Thank you for having me.
It's my pleasure. You know, Dylan, North Carolina has a reputation for strict DWI enforcement. When a driver sees those blue lights behind them, what should they realistically expect to happen in those first few moments of a stop?
Well, I mean, in many ways, it's like any other traffic stop. You know, law enforcement officer is going to come up, begin to interact with you, ask you probably for license and registration, and then start to ask you questions. And those questions that are being asked are part of the information gathering aspect of the stop. It's part of the investigation. So literally from the moment that a police officer is tapping on your window or beginning that interaction with you, more likely than not, they're taking it all in to try to figure out what their next steps are going to be.
Many people don't understand how officers decide whether to extend that traffic stop, into a full DWI investigation, but it's everything we say and do from the moment that they approach us. So what kinds of observations typically trigger that shift?
Yeah, and that's an excellent question, because really the way the analysis of a DWI works is you look at why somebody was pulled over in the first place. Oftentimes it's not for DWI. It's a lot harder to justify a stop based off of DWI in many respects. That doesn't always play that way out in court, but by the law, it should be a little bit. But a lot of times people are pulled over for other Chapter 20 traffic violations within the North Carolina general statutes, whether it be speeding, running a stop sign, failure to maintain lane control, whatever it might be. So they're pulled over for that at first. But then there's the Supreme Court case that talks about how an officer has to establish separate, independent, articulable, reasonable suspicion to then extend the stop to investigate a DWI. And so what they're looking for are your admissions. Did you admit that you had something to drink? They're looking for what your eyes look like. Are they red and bloodshot? Are they glassy? Is there an odor of alcohol in the car? Now, there could be any number of reasons why there's an odor of alcohol in the car, but then that can be bolstered by the fact of if you step out of the car and that odor still remains, it's probably on you. And then they also look for potential slurred speech. But then again, you've got an officer that's never interacted with you before, and people talk all different sorts of ways. You could have language barriers. There's all sorts of things that play into that. So any number of those things can add up to potentially be enough to extend the stop for a DWI investigation, but every stop's a little bit different.
And then field sobriety tests are a major part of a DWI case, but most people don't know how they're actually evaluated. What should someone understand about how those tests are interpreted?
Well, to be honest with you and quite candid, we run across plenty of officers that don't know necessarily how to properly administer them. And that's an aspect of looking at the defense of somebody for a DWI, is whether or not the officer did the things that they were trained to do. Because the key word there is standardized. If it's standardized, it's got to be done the same way each and every time, because that gives some indicia that you can rely on to then draw a conclusion. And that's what they're trying to do. They're trying to draw a conclusion based off of your performance of those tests to then investigate you to try to develop probable cause to then arrest. So, I mean, the evaluation of that is laid out basically in like a rubric by the National Highway Traffic Safety Administration, also called NHTSA, where you've got clues. And an officer looks for specific clues under each of the standardized tests, and there's three main ones. And did you have 4 out of 6 clues on one? Did you have 3 out of 4 on another, or whatever it may be? And all that adds up, and that could be enough to support a conclusion of probable cause to then arrest you and take you down to the station. Another aspect of that are portable breath tests that are done on the side of the road. In that situation, the actual number that an officer gets on the side of the road is not admissible in court in the state of North Carolina. The only thing that is admissible is whether it was positive or negative for alcohol, or whether or not you refused the test on the side of the road, because you can refuse a roadside breath test in the state of North Carolina.
So there are serious consequences when you refuse a breath test. How does the state treat refusals, and what makes this area so different from other parts of criminal law?
You're exactly right, but you kind of have to parse that out. So the test on the side of the road, the portable one with the little sensor, and they put the straw in your mouth and you do it on the side of the road, your refusal of that doesn't really have adverse consequences towards you, except for an officer being able to say in a courtroom, they refuse to do this test. However, if you get arrested, they take you down the station, you refuse a breath test, you refuse a blood test, whatever it may be, significant consequences. You lose your license for a year, guaranteed, because having a license in the state of North Carolina is a privilege. It is not a right. And so by having that privilege, there's implied consent that you give by having that driver's license that you will comply with a breath test upon arrest of suspicion of DWI, or a blood test. And like I said, that refusal will mean a year suspension of your license. Now, you can apply for a driving privilege after 6 months. Normally, it's after like 10 days, just depending upon the circumstances of the DWI, but most DWIs is about 10 days. In a refusal case, you're looking at 6 months. Now, there are ways to potentially challenge that refusal with the North Carolina DMV, but those issues are very, very nuanced. Sometimes we've been successful in them, sometimes we haven't. It's usually been a procedural issue where an officer's messed up on that, because more often than not, if you refuse, and it's pretty tough. I mean, your suspension's gonna happen.
That's great clarification, because you don't realize that there's multiple times when that's going to be happening, where you're going to be asked to do a breath test. Without sharing any details, is there a moment from a past case that showed how one small detail in a stop, something most people would overlook, may have changed the entire direction of the DWI charge?
Arguably, yes. I had this case one time with this lady. She was a Spanish-speaking individual, and the trooper was not. He spoke more Southern than English, and if I'm being quite candid, I'll never forget that video, actually, of watching that. But I remember sitting in court, and I had an interpreter there beside of me for her so that she could understand the courtroom hearing. And I remember the judge stopping at one point and going, how do we expect her to understand how to do the field sobriety tests if this officer doesn't speak Spanish and she obviously doesn't speak any English? And that was something that, I had picked up on, and I had taken that case over from somebody else and had keyed in on that fact. And you know what? It was a fight. But at the end of the day, we won because there was no way you could confirm that she understood any of those tests. And it was pretty obvious she didn't seem to understand those tests. And when you have two people that speak the same language not understanding the test, it's usually an indication of intoxication, right? But when you've got somebody where there's a massive language barrier there, and all of a sudden they don't know how to do the test, you can't say that they understand your instructions. And that is a requirement based in the National Highway Traffic Safety Administration manual on how to administer those field sobriety tests.
Amazing. So small micro things that make a difference in the case. Let's shift gears to chemical test results. They seem straightforward, but you've worked enough with these cases to know that there's more to it. What kind of issues can affect?
Yeah, there's a lot of issues. Usually they usually take longer. To get those blood results back usually takes longer. So you can just bank on the fact that your case will last longer than a normal DWI. Second thing is it's important to have somebody as your counsel that knows how to handle those types of stops and those types of DWIs. Because there are nuanced aspects of it related to filing proper objections related to blood even being able to come in. There are special admissibility requirements that the state of North Carolina has to tick off every single box for those results to come in. And if they don't, we've been able to successfully keep it out because they weren't able to lay the proper foundation. And if you can't lay that foundation, you can't get those blood results in, then that is a major piece of ammunition that the state of North Carolina doesn't have in its pocket to be able to move forward. It doesn't mean that they can't move forward. They can still try to get you to be found guilty based off of what's called appreciable impairment, but they don't have that chemical analysis to try to do that. The other thing that I've had in chemical cases where I've been thankful that I've had a chemical case is with somebody who was on prescription medication. And in that sense, we weren't able to use that as a way to get that individual not guilty in any way. There are things carved out that say that that's not an excuse for a DWI. However, it is a significant mitigating factor. And so we were able to hire an outside expert pathologist to analyze that blood and what was in the blood to be consistent and to line up this person. I mean, they took a lot of medications to be able to line it up and talk about the interactions among those different medications and how it might affect that individual and lead to what happened that night that they were pulled over. And you know what? It ended up going from a kind of an upper level DWI to the lowest level DWI you could possibly get because of that outside expert.
Once someone is arrested for a DWI, the process moves really quickly. What do the next 24 to 48 hours typically look like from the booking to bond to early court appearances?
Sure. And that aspect of it is quick. Everything else usually can be slow. But in that first 24 to 48 hours, you're exactly right. A magistrate is assessing you for whether or not there are release conditions that are safe for you, safe for the community. Do you have somebody that can pick you up? I mean, there's any number of things like that where it could be like a custodial release. In certain counties, Forsyth County being one of them, a lot of times you do have an immediate follow-up court date as an initial appearance, usually the next day or the day after. And all of a sudden you're having to do all this stuff right away. And then on top of it, not having a license to be able to get around. So you've got to figure out how to get around on top of it. The other thing that's really critical, in my opinion, in that 24 to 48 hours is getting in contact with an attorney. And the reason why I say that is because an attorney can properly advise you of very critical next steps that you need to be mindful of and go ahead and start trying to get help with so that you can get things like driving privileges, so that you can have peace of mind that somebody's looking into the stuff, so that somebody's reaching out to the district attorney's office and trying to get the discovery as quickly as possible. All those things, together, I absolutely recommend people being more on top of it in this regard. I always do, but with DWIs, it really matters.
North Carolina's sentencing grid for DWI is unique with levels and aggravating and mitigating factors. What should people understand about the way those levels are determined?
So that's exactly right. It completely separates itself out from any other misdemeanor, from any other felony, whatever it may be. DWI is different. And what a judge has to do is they have to weigh the aggravating factors against the mitigating factors. And then if there are grossly aggravating factors, then the mitigating factors can help and it can put things into context and certainly be something that helps the overall sentencing outcome. But if you've got grossly aggravators present, you're pretty much locked into a few specific outcomes. And the most common in that is a prior DWI within the last 7 years, getting a DWI while another DWI is pending, having a child in the car, stuff like that, can be grossly aggravating in nature. Then you've got aggravating factors like that your driver's license was revoked, that you were involved in a wreck. You got gross impairment, which would be impairment of 0.15 or more. So basically almost double the legal limit of 0.08 or more. But then you also got mitigators. And those mitigators are things a lot of times that can be in someone's control. So submitting yourself to a substance abuse assessment is something within your control, and is a critical part in helping get a driving privilege for a lot of people. Doing whatever their recommendations are, big mitigating factor. Like slight impairment, 0.08, 0.09 or less is a mitigating factor. And then there's a catch-all, and that catch-all can be considered by a judge based off of, what's this person does, is this a complete and utter aberration for them where, it's completely out of character and it's very obvious that's that, or they've submitted themselves to significant life changes, whether it be sobriety or whatever else, and that can be shown. But a lot of times it's about having proof of that stuff, being able to adequately present it, and then weigh it against those factors. So if the mitigators significantly outweigh the aggravators, it's the lowest level DWI, it's level 5. If they're pretty equal, it's a level 4. If the aggravators outweigh the mitigators, it's a level 3. And then levels 2, 1, and there's an aggravated from that tend to involve those grossly aggravating factors at that point. And so every bit of that affects, our approach, what we advise, our analysis on whether or not we go to a hearing or a trial, every bit of that. But yeah, that's what a judge has to do. It's not easy.
This is not a path someone should walk on their own, for sure. It's,
Are you picking up on that?
when you say, let's get an attorney involved in the first 24 to 48 hours, when we hear these consequences, it makes sense.
Yeah, I have a friend of mine who's a prosecutor in another county that always joked that if you can thoroughly litigate a DWI, then you can do a capital murder case, because there's almost just as many constitutional issues, there's just as many nuances, every bit of that. And to some degree, she's right, because there's a lot of little stuff in there, and being able to know what to look for is critical.
Is there something, what should they know about how evidence in a DWI case is, reviewed, and how those details can influence the direction of the defense?
So both good and bad, a lot of it comes down to what the video looks like. Some counties are really forthcoming with that. And I mean, I always applaud that, because that can usually sway it one way or the other. Okay. And, because there are many times that I am in a consultation for a DWI, the interaction is described one way, and then, maybe the video is different. And then that conversation becomes different with my client. And, it becomes less about fight, and more about, hey, let's counsel you and steward you through this difficult time. And we do that for a lot of people in a lot of different kinds of cases, but happens a lot with DWI. When we get videos, when we get reports, reports are always something that you have to look, between the lines on, regardless of the case. And knowing how to do that and kind of read that subtext is critical. With videos, you got to be able to break down the interaction, look for those little details, those little observations, the different parts of the field sobriety tests. Did they get all the instructions right? Did they administer it correctly? Did the officer position, somebody right in the face of those blue strobe lights? There's no way that you can do a horizontal gaze nystagmus test while you've got strobing blue lights in your face. That's going to mess anybody's vision up, right? So, I mean, there's all those things that you look for, and it isn't just like a rote step-by-step thing. You're trying to take the holistic totality into account.
I hear you. I hear everything that you said. Folks, that's it for today's episode of For the Record with Greenwood Law. If you would like to learn more about attorney Dylan Greenwood or the work that he does with Greenwood Law, we encourage you to reach out to dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal charges. And we really want to thank you for listening. And don't forget to leave a review, and subscribe. Pass this show along to somebody else who might need it. And Dylan, thank you for being with us today.
Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.